The next session, friends, would be on the webinar. Friends, this is something which all of us have in our mind whenever we take up an assignment. It is not just a corporate insolvency resolution process. It's not just a liquidation process, or it's not just resolution of personal insolvency or personal guarantors. It is basically a combination of all the pain points which we want to discuss here. So basically, friends, the rule of the game is like this. What we will do is we will have I'll invite couple of members of our this thing to join me, and thereafter we will discuss on the theme. The theme of this today's webinar is breaking the silence, addressing pain points in the insolvency profession. Friends, I will request our co-panelists to Mr. Ravichandran, T.R. Ravichandran, Mr. Vikram Kumar to join me. And of course, Dr. Makija, who can definitely help us in getting some clarity. Mr. Vikram Kumar and Ravichandran, sir, thank you so much for joining. Friends, as a rule, what we will do is, if at all you have any, so basically what happens is we have about 200 and more than 200 people here, at the 223 to be precise as of now. Now what happens is, if you have any queries, we will, or suggestions or some solutions, now we will not spend too much time on addressing too much of challenges. We'll try to find out solutions for the pain areas. That's the whole idea about it. So if you have any points to raise, please raise your hands or put it in the chat box. We'll definitely get back. Vikram sir, shall I start with you? Can you
Yes,
just
sir. Yes, sir. Thank you very much, sir. And sir, thank you for this opportunity. So the pain point, I would like to, address the first pain point is the timely payment of CIRP cost and fees to the insolvency professionals. So, sir, on this point, all I want to say is that the expenses and the fees are approved by the COC, but they are not paid by the COC. So what happens? The approval has no meaning if they are not paid in a reasonable period of time. Moreover, there is a section called 17 subclause 2 subclause E, which is actually a big responsibility on the IPs to carry out all statutory responsibilities on behalf of the company post commencement of the CIRP. So if the IPs are not paid in time, how is the IP supposed to carry on his duties is the issue I want to raise as the most burning issue which we are facing as an insolvency professional.
Okay, Mr. Vikram, friends, I will be kind of moderating or chairing the panel. So I think we have got fantastic panelists. Even Mr. Shankar Panikar will also contribute. We'll also hear from all of you. But let us go to the first point. Mr. Vikram Kumar, you have raised a very important aspect of non-payment out to the IPs. I think everyone gets affected, isn't it? But let us look at the solution. So if I come to you, please tell us what could be the possible solution which can be recommended to the government, to the regulator from on behalf of the IPs. IPNet will definitely take those steps in recommending that. So what would be the possible solution according to you?
So, sir, in my view, we have regulation 31A in the CIRP regulation, which provides for the payment of regulatory fee to IBPI. And if there is a delay in payment of regulatory fee, there is a 12% simple interest to be paid to IBPI for every delay. I think, it's a time that for every delay in payment of fees and cost to the IPs, we should have a provision for payment of interest to the IPs also.
Okay. So interest payment on that. But of course, interest payment is definitely a good suggestion, but that does not still make the payment to the IP. So idea is we are still looking for the payment because there are financial crunches there. So naturally,
sir, on this point, we have been, requesting IBPI for a code of conduct for the COC. Unfortunately, that code of conduct is not coming. And whatever is coming is very directory in nature. It has no binding nature.
Correct. Absolutely. I think that's a fantastic point which you have raised. Now let us go over to you see, another panelist, Mr. Ravi Chandran. Yes, sir. Do you have, yeah, can you unmute your, yes, you are unmuted. Friends, we will
Sir,
also, let's do this. Let's hear from three of our friends, and then we will make it open because this is your program and everyone will have the voice today. And we will try to solve as much as possible. Of course, in a period of 1 hour, we will not be able to handle 50 problems, but let's see if we can handle, say, 5, 10, 15 problems, and we can represent the IPs before the government authorities. Yes, Mr. Ravichandran.
Sir,
Over
thanks
to you.
for the opportunity, sir. Actually, IP's problem are, in my opinion, there are, it can be divided into two. One, the case-specific problems. Another is generally in all the majority in all the cases, these are the problems. So I would like to discuss the second one, that what are the things which are common in all the almost in all the cases, of which one I would say that the attachment of bank accounts by PF and the IT authorities. See, what happens is when the company goes into CRP, obviously, they are defaulted in, the PF and other things actually. So they attach the bank accounts. With the result, when the IP, already the company is not having money. And if they want to, remove the lien actually, it becomes a very tough task. And especially when the banks are in small towns, So one, they don't have the record, or two, even they have the record, they do not know what to do, and they say that we have to receive instruction from you get a letter from our head office, like that they are saying. So the removal of attachment of lien is a major issue, sir.
Okay, lean issue. So what is your solution? I mean, I'm asking everyone who is raising a problem. We are not looking at the problems alone. Friends, we are looking at the solution today. So what, according to you, is a possible? So friends, if you are raising a problem, please also suggest a solution. Because problems, I think everyone knows nowadays, isn't it? So I think we are here to discuss the solution. Yes, sir. Please go ahead. Sorry, sir, you are muted, sir. Can you unmute? Yeah. Please go ahead, sir, now.
Yes, sir. Actually, what I suggest, sir, when the CARP order passed, actually, they should, see, it is very easy to know, even in the application, what I suggest is, if they can inform the financial creditors. They can inform the financial creditors, and they also have the IT details actually, which is circle and all. So even in the CRP order itself, they can say that if there are any lien is there, it has to be removed. Similarly, the PF circle and other things. This will solve a lot of problems, sir, because the court order will be there, and we need not again go to NCLT for getting an order to remove the lien, sir.
I think this is an excellent achievement, friends. Look at this. I mean, the solution is also coming. Rather than we going back for every time we find that there is an PF attachment, there is an income tax attachment, there is so and so statutory authority department. Why can't a general word sentence can come in the order itself that all authorities are hereby directed, including banks, to deattach, to take up, to remove that lien. I think that's a fantastic suggestion. This should be a part of the order, or rather it can also be a part of section 14 also. I mean, in moratorium, then we can say that in moratorium, there will not be any lien also. I think we can modify section 14 to certain extent to that. Good suggestion, sir.
Excellent, sir. If the code is amended, nothing like that, we can even
Right.
inform about the code.
So even if the code is not amended, at least till that time, the benches can add in that order. Nobody's stopping them. In any case, they are also removing the attachments also. Good suggestion. Thank you, sir. Thank you.
Thanks.
I think
Thanks.
Mr. Panikar also has some point to be raised. So, Mr. Panikar, if you can unmute yourself and please come over, if you are hearing me.
Audible, sir? I'm audible?
Yes, sir. Yes, sir. Please go ahead, sir.
Fully agree to that view. I just have another way of looking at it, sir. For example, I'll tell you what has happened in the case of Customs and Central Excise and KSEB in Kerala. They have a dedicated, a division or a person who will daily look into this IBBA website, whether this has been, any company has been admitted to CIRP. And thereafter, they will, in fact, I personally, I was invited not just 2 times, more than that, to know how to go about it the moment they get this order, moratorium and all those things. So basically, in Kochi, in Kerala, other than local state government, central government has a bit of evolved. And thereafter, if we take up, I think we have a role here, as far as IPNet is concerned, that we have a role here. See, there are certain things which legislature has to take. For example, take the case of 10A. 10A essentially talks about COVID period default. Now, if you go by the section 10A, section 7, section 9, and 10, it is not talking about 95. So therefore, it has to be, in my case, I have taken it up. So IBBA, we don't know. If had it been IPNet at that point of about 2 weeks or 2 months, 3 months back, it would have been, I would have got a collective, bargain on that. So nobody was, including the learned technical member and the judicial member, was against my argument. They said, why don't you take it up? We don't have it.
Right.
We don't have powers. So basically, it is like a reverse. We should take it up with the department saying that, look, this is a violation. Why don't you, every time when a budget comes, there are certain discussions happening in the department, in the government departments. Once we are in the top of the mind recall, it will happen. In Kerala, it has happened. That is my
Right. Great, sir. Great point. In fact, I'm looking at the chat box also. Mr. T.S. Siva Prasad has given a fantastic suggestion. He says, Indian Bank Association should direct all the member banks to educate their employees to go by the NCLT orders regarding account operation fees. Excellent suggestion, sir. I think at IPNet and all those who are ex-bankers, my request to you, to them is, please come to us. We will also hold these kind of webinars and seminars with these authorities like bankers or the government authorities. And please let us know if you have some networking, if you have some connects, let's also start doing. It's an excellent suggestion, sir. So he also says likewise, PF department should also be educated. Right? Yes, the educating the statutory authorities. In fact, Mr. Ravinder Chaturvedi, who is heading the IPNet West, in fact, he also took on that responsibility. And we have a separate study group, my dear friends, under IPNet. The website is live. Once you go onto your dashboard, there will be on the right side, you will find study groups. You can join study groups. There are 11 study groups which we have created, and they will be very active. They are being headed by very competent people. I'm also heading one of the study groups, which is personal insolvency. But other people are also there. So please join them and contribute so that we can have a unified voice. Excellent suggestion, Panikar. I think now what we can do is we can take a few of other members. I think Mr. Narendra Kumar Sharma, he has raised his hand for quite a long time. In fact, he wanted to ask a question to our chief guest, but unfortunately he could not. So, sir, please unmute yourself. And if you have any pain points for the insolvency professionals. Yes, sir, please go ahead.
Good evening, everyone.
Good evening, sir.
So my question is again relating to statutory authorities. TDS deducted on the income generated during CIRP is being adjusted by the income tax department relating to prior to CIRP recoveries.
Okay. So what's your view? That should not be adjusted?
That should not be. That should not be, because that will be a violation of the moratorium.
Okay.
Because the income tax department is supposed to submit their claim relating to all their claims prior to CIRP before the IRP and RP. They have no right to recover it from the current income generated during CIRP.
Yeah, absolutely.
So I think the similar instruction can be passed in the order itself, admission order itself.
Okay. Yeah, similar instruction and also education to the income tax department, right?
Yes.
Great, sir. Thank you so much for being a part of it. And now we will go.
I have another question relating to real estate matter. If you allow me at a later stage, I will definitely would like to share that.
The real estate study group, I believe you are a part of it, isn't it?
Yes, I'm the part of it.
So hold your meeting and discuss anything you want with the members. So I'm so happy you are also a part of the IPNet.
Yes. Right,
okay.
sir.
I think I will go to Mr. S.M. Sundaram. SMS. Wow, what a name. Sir, if you
Thank you, Ashish. I am here because of your request. I am here.
Thank you, sir. Thank you.
Am I audible, I suppose?
Yes, we can hear you, sir.
Okay. I'm not representing the insolvency professional, but consistently, since you are also being lawyer for the official liquidator,
Right.
this threshold of 1 lakh to 1 crore, whatever it may be, it was copied from our Companies Act for Section 433. You are aware of it. I know you know it about it.
Right.
Keeping in view of the issues raised by our insolvency professional, I have consistently been maintaining that why are they still now, even now they are restricting the threshold to 1 crore rupees. It should in fact be 10 crores rupees, so that the bankers are able to release the funds to our insolvency professional upfront. Some people have also here written that upfront payment has to be made, and also whatever expenditure has to be incurred by them officially, that has to be met by them. Keeping in view of that and the cost of the CARP process, why not the threshold be increased to 10 crores? We should be coming forth very clearly. 1 crore is not at all a threshold limit at all for this kind of such a big events.
Okay.
If not, again, Mr. Makijaji, I just want to just think of Securitization Act. The threshold has been increased to 100 crores also, if somebody had written about it. If not 100 crores, at least 10 crores should be there. That kind of law should be amended, and the insolvency professional should not have any problem in amending that law, because they know that they are doing it free of cost for such a long time. They are not coming and openly telling about all these things.
Okay.
Any number of applications. 1 minute, sir, Ashish ji.
Yeah. I think
One.
we have a large number of people. Anyway, sir, please conclude, sir. Please.
Yeah,
conclude.
बस एक ही point है. Sorry. And keeping in view of this, I would like you to make a suggestion that the the threshold limit should be 10 crore rupees. We cannot copy the Companies Act, that is especially 1956. That is mainly concern I am producing before you. Just let us see what others are speaking. Thank you.
Thank you, sir. Thank you. Friends, what I can agree with him is upfront payment. And how that upfront payment and other security, I mean, that what to be provided for securing the fees. There are twofold things which can happen. Number one, the NCLT, which is typically directing payment of 1 lakh, 2 lakh, or something like that. I think they should increase that amount. At least for 6 months, fees of the IP should also be put in an escrow account. What is the problem? If the CRP is over before that, the money will be refunded. What is the problem? Because then the seriousness will come in. Number two, look at PPIRP. What does PPIRP say? PPIRP, you can start only when you sign an engagement letter with the RP. Isn't it? Now, where is the engagement letter in this case? When when NCLT appoints you, I think these points should be made mandatory. That there should be a proper engagement letter so that there is no quarrel tomorrow. Two, payment of upfront fees as much as possible, right? So I think it can be a percentage of the claim also. It can be anything. I mean, we can suggest. That is for the government to look at. I think these are good suggestions which are coming, but I don't know whether the increase of the limit, every IP will be happy about it or not. So I'm not taking it up, because in any case, many of the people are still saying that they are not able to get work. So if we increase to 10 crore, how many IPs will be not getting work? So at this moment, I will not agree with that, sir, with due respects to you, but your points are well taken. Okay, great. Now I think we can go to Tina. Yes, Tina Saraswat. Yes, Tina ji, please unmute yourself. Are you able to unmute yourself? Okay. Yeah, now you're unmuted. Please go ahead.
Good afternoon. Good evening, everyone. My first suggestion will be like during CRP, we all face fund crisis. So, in order itself, it may be mentioned that fund can be taken by RP at so and so percentage. And so either IBBI can set up their own institutions and recommend that these institutions will fund CRP process, because it is very troublesome for us as an IRP to carry out the CRP without funds. Secondly, the COC member who files a petition against other COC members and RP, and if RP is leading the case, then the percentage vote of that COC member should not be counted while approving the fees. Because in one of my cases, one of the member is 52%, another are 48. 48 is always approving the fees for defending the certain petition against the major lender. But I am not getting approval of 51. So I am stuck. I have spent my money. I am not getting it back. So there should be a provision that a COC member who has filed a petition has no right in approving the fees. Because if they are given a right, then no one will be able to defend. Then why IRP is representing COC? Then IRP should only represent one bank who has an approval right. And thirdly, sir, in PIRP, there should be a fees fixed, like it is in CIRP, because now it is against that market is there. Reduce your fees 1,000, 2,000, 3,000. So quality will obviously be deteriorated there also, because getting work is some other thing, and working and doing the task is other thing with the minimal amount. So quality can be expected when some target minimum fees is fixed, like they are fixed in CRP process. And thirdly, I have one question, sir. In white paper, there was some amendment for real estate. Are there these amendment included or still there?
Okay. I think we have got given good suggestions. In fact, as far as the PPIRP schedule is concerned, in fact, I would say.
And one more thing, I would request, sir.
Let me complete this.
Suggestion.
Yeah, just a sec. So PPI, not only PPIRP, in fact, everyone would like to have a standard fees for even personal insolvency cases. So when we are saying fixed fee, schedule, probably we are talking about not only CRP or liquidation, we are talking about the entire IBC ecosystem. So friends, I think that's a good suggestion. We will definitely look into, and we will consider within ourselves also, and then make a very strong representation on this particular aspect. Yes, Tina, very quickly, because there are a lot of people who have raised hands, so we have to be very quick, and there are a lot of issues are coming in the chat box. Yeah, we'll unmute you, don't worry. Yeah, okay. Yes.
One final suggestion, like income tax, PF and other authorities which keep us troubling every now and then, there should be specifically stated in order. You can make an assessment, the authorities can make an assessment during CRP, but they cannot initiate recovery. It will be more than sufficient for all of us, because what we are facing, they make an assessment and then they send an order for recovery.
See, Tina, that is not a problem of IBC. That is a problem of lack of knowledge, because there are Supreme Court judgments, right? There are Supreme Court judgments which are clearly saying that recovery is not possible under the IBC. Only assessment is possible. So I think they need to be made aware of that fact. That is the whole. Okay, great. Thank you so much. Friends, now, Mr. Ravichandran, while I look at the you see chat box, we'll unmute others also. Do you have any other point to make? Very quick point.
Oh, very quick points are 2 points only, with your permission. One is this. See, the 19.2, in most of the cases, what is happening is we are not having the details of the fixed assets actually. So that becomes a big problem to start either the valuation or to ascertain the value of the company. For everything, the impediment.
Yeah, I think, okay, I think we are not able to hear him. So I think his screen is frozen. Maybe we will look into, you see, some other questions. Friends, are you able to hear me?
Yes, sir.
Yes.
We can hear you.
Yes, sir.
Okay, because there was a complaint that my voice is pretty low, so now I think I should be okay. Okay, now I'll unmute Mr. Mahesh Chand Gupta. Mahesh ji, yes, please go ahead. What is your point which you want to make, sir?
Yeah.
And give the solution also.
Yeah, thank you. Yeah. I'm coming to that only. Whatever I would like to say, it has already been discussed. And
Right.
as we are facing two problems, according to me now today, one is COC, second is judiciary. So, as Mr. Kumar said very rightly, there has to be a system, and we must, if Mr. Kumar agrees, under the leadership of Mr. Kumar, we have to make a system or proposal to the ministry, like number of benches, members, as well as quality. So
Right.
that the cases are disposed of quickly.
Right.
And what we discussed that even if we put something in the order like we discussed, there should be direction to PF to release to this, that, but this doesn't happen. And if you file an application to NCLT, it takes months. So by that time, your matter is again delayed and nothing. So that training to each and everyone, authorities plus CUC, through IBA, somebody suggested, or directly with the heads of the bank, we can take up as from IPNet platform to train every and each and every. Thirdly, for non-payment of CRP cost, there should be a penalty clause for that particular officer or a person. If they do not pay after approval for COC, there has to be penalty for that.
Okay.
This is
Great.
the three shortly I can say.
Great, sir. Good points. Very good points. In fact, the quality of benches, the increase of the benches, I think these are the points which were also red flagged by Justice Kumar. I think these are fantastic suggestions. We'll also work in coordination with them. Thank you, sir. And now, friends, I'll just take one question from the chat box. Mr. Harvinder Singh Dhami says, I would also like to talk about the validity period for an AFA in the context of IPs. 1 year validity period might indeed pose challenges. Harvinder ji, I must tell you that all the IPAs are working together and they are going to make it as a continuous, validity. So they are not going to restrict. So you will see those changes in coming months. I think, but it's a good suggestion, but they are already considering this. And of course, secondly, he says IPNet makes efforts that webinars conducted by IPNet are recognized for CPR. Good suggestion, sir, but we'll see. We'll also work with the IPBI and IPAs that you must allow even the private organizations, not only IPAs, to give CP hours. Yes, that's a good suggestion. I definitely agree with that. Okay. And of course, Mr. Rajiv Khurana says, public announcements made by liquidators cost rupees 50,000 plus advertisement, but cost is not sure. Yes, sir, your concern is absolutely valid. No difficulty in that. Okay, now we will hear from, Sandeep Chitkara. Yes, Sandeep, I'm unmuting you. Please go ahead. And we don't want to hear a problem. We want to hear problem with a solution. Okay? Yes.
Yes, sir, certainly. Good evening all. So actually, so I'm handling certain cases and there are problems with respect to 19.2 issues. So non-cooperation is always there. So some other member also pointed out that very thing. So now there is in other case, there is a Form G stay, so which is now languishing in NCLAT. So and in other cases, so I'm not getting assets which are in custody of various statutory authorities. So my point here is that all of these things, and in various cases, are actually, so there is postponement in all of these applications. So 5-6 postponements are already there. Some liquidation cases, orders are to be there, but those are basically being postponed since last 8 months now. So my thing is that actually regarding the Chandigarh bench, so because all my applications are at the Chandigarh bench. So major problem over there is that there are 2 benches, but there is no infrastructure over there. So when one of the bench rises, the other bench sits. So despite the fact that there are 2 benches, so they are actually not working in tandem. So there is always a problem over there.
You are saying that there are 2 courts are not there. There is only one single court.
Okay. Yes, sir. Yes, only a single court is there. So this is another problem. So 2 benches cannot work.
Yeah, if 2 benches are working full time, and naturally they can dispose of more matters. Your point is very much valid, which is particularly for the Chandigarh bench. Yes, sir.
So moreover, my request here is, my suggestion here is, regarding, in all of the cases, we do see that there is non-cooperation from the erstwhile management. So in 19.2 cases.
Sir, we are all aware that there are a lot of issues. Sometimes the promoters are absent.
My suggestion is, sir, so what I want to suggest here is that regarding this is actually the crux of all the insolvency processes. So to proceed, we need papers and everything and information. So 19.2 applications should be actually put up in the priority list or maybe the supplementary list. So in the supplementary list, usually we see is that resolution plans are taken up. So that very supplementary list, 92 applications should be taken up. They should not be postponed.
Well, let me ask you a question. There are now priority list is also getting longer, right?
Yes,
As
yes.
far as the Ministry of Corporate Affairs is concerned, admission of matter is a priority. As far as RAs are concerned, resolution plans are important. As far as IPs are concerned, every application is important, isn't it? Including 19.2, payment of fees, so many other things. So tell me, in the order of priority, what should be the top priority and the second priority and the third priority?
So, sir, according to me, when we actually initiate the corporate insolvency process, so we do need actually some kind of cooperation from the management and
That's all.
every other person who is actually associated.
Right.
So this is actually the starting point. So
No.
that is my point.
You see, what I like to know from you is 19.2 is there. We have seen 19.2 has not been very successful, right? Now we want to change the regime. It should be now IBC 2 or 3.0. People are talking about IBC 3.0. I don't know. I want the entire reshaping. What should be the section? Now, what my suggestion is, one suggestion I can give. The promoters do not cooperate. They do not hand over the books of account. Whenever an application is filed against the corporate debtor or the corporate debtor files it, it should be made mandatory that they should file the latest, balance sheet, right? Signed balance sheet, the latest audited and also the provisional balance sheet, and should also give an averment that all the records, books of accounts are kept in their custody. And if the CRP starts, it will be given on the next day. I think, and supposing they don't do that, then their reply should not be taken on record. They should not be allowed that we will not hear you there. So I think this is because this is already included in the new Companies Act in the winding up matter, but unfortunately the matters travel to IBC. So I think this is one suggestion probably which we can include, isn't it? I think my friends will agree to
So
that.
moreover, there should be a fixed time frame wherein, like you said, that there should be cooperation.
सर टाइम फ्रेम तो ऑलरेडी है ना सर, वो तो अब कोई कॉपरेट ना करे तो क्या करेंगे. चलो ग्रेट सर, थैंक यू सो मच. आई थिंक यू हैड रेज वेरी गुड पॉइंट्स. Mr. Vikram Kumar, can you just one of our panelists, sir, the suggestion which we have given on 19.2 and the other things, what do you think should be done to strengthen 19.2?
So, on 19.2 or the litigation by the promoter is a very burning issue and one of the major reasons why processes are not getting completed in time.
Correct.
So I am the view, sir, that if a promoter is not cooperating, he should be barred from filing any application in the NCLT or in any forum under IBC. So he does not have a right to not cooperate and at the same time litigate. So he's not cooperating, but he's litigating.
I don't know. A lot many lawyers are there. I'm also a lawyer. I don't know whether it will be a breach of fundamental right.
So, I'm giving a very, out of the box kind of an idea. Because if the books of accounts are not complete, if the statutory records are not complete, anything is not complete up to the insolvency commencement date, he loses his right to litigate.
Right. All right, sir. All right. That's a fundamental right. I don't know. We have to amend the constitution there.
Violating Article 21, definitely. It has to be quantified. See,
does.
basically, I'll just add one point to that. 19.2 should be, according to me, 19.2 should be clubbed with 66.1b.
How do you do that, sir? Can you just explain?
Because if a promoter willfully or not able to give most important documents, there will be something they are hiding. For example,
so they should be guilty for the fraud, right? Straight away.
Their purpose
wrongful trading.
Absolutely, and that too, they are not reducing the impact of CIRP.
But sir, if they don't cooperate, there is always penalty provision from 68 to 77. There is already this provision, but unfortunately, that provision cannot kick off because that complaint has to be filed either by the IBBI or by the Ministry of Corporate Affairs. IPs cannot file. So the point is, if IPs are allowed to file a penalty application, I think that should be the criteria. Then the promoters will think that there is some urgency attached to it. Because, if in 19.2, the benches are very strict. Sometimes they issue bailable and non-bailable warrants. The moment non-bailable and bailable warrants are issued, I have seen in 99% of the cases, promoters actually start cooperating.
That's what they'll go up to that limit and go back. I mean, they will oblige.
True. I think that's a good point which you have raised. So friends, now let me go back to one of the you can say the chat boxes. A part of moratorium, CD's bank account is auto protected from freeze. That's all right. Okay, Mr. Jakani says, Srinivas Jakani, in my opinion, at the time of filing of Form A with IBBI, IP fees shall be routed through IBBI. It means CD, OC, or PG has to deposit the amount with IBBI on mutually agreed manner. It will pay. Okay, Mr. Jakan Srinivas, I think I would not like to involve government in this. Of creating a fund or involving IBBI is never a good idea. We should get out of that. The only thing is what your suggestion is slightly modified. Let's create an escrow account. Let the NCLT direct deposit 20 lakh of rupees, show your bona fide. Right? Naturally, it's a part CRP cost. The applicant, whosoever is, he will recover it. Why IP should be suffering on this? So I think creating an escrow account, I think that should be the good idea. But anyway, sir, good point which you have raised here also. Okay, I think Mr. Mujahid wants to ask a question or maybe has some issue and problem and the solution. Yes,
Yes,
Mr.
sir.
Mujahid.
Yes, sir. Good evening to all.
Again, same request, sir. Give us a problem, give us a solution also. Okay.
First, I want to touch on that only.
Yes,
Dr.
sir.
Makija has reminded me of my ICSE bank days. Those days, even a ground level officer can attend a meeting of KV Kamath and
Right.
flag off issues, but with solution. It's
Yeah.
mandatory that you have to suggest a solution. See,
Absolutely.
my suggestion is when we interact with the IBBI for various things, the response level is very poor. For example, I am handling a personal insolvency matter. I wanted to add that assignment in my dashboard. But in the dashboard, in the drop-down window of the nature of assignment, bankruptcy trustee is not included even now in the master data. I have flagged off this issue as far back as February 2024 to the technical team under copy to Rahul Khanna and even ICAI monitoring. So far, there is absolutely no response. So my suggestion to overcome this is, in banking, we use this customer relationship management portal. In ICICI Bank, we are having Finacle CRM, the FCRM, whereby there is an escalation matrix. If the particular individual doesn't handle the issue within the turnaround time, it flows to his boss, and then to his boss, then to even to the MD it goes.
Okay,
so we can have a portal like that in IBBI, the auto flow of the issue if not resolved to the next level. That's my suggestion. Thank you very much.
Fantastic, sir. I think that's a good suggestion. But in fact, as far as my news is concerned, IBBI is revamping its website. They're bringing out with a new, very state of the art all these facilities. So I think though in the next batch of updates, probably this will also be done. So, but thank you, sir. Auto escalation is very important of the complaint or of the issue which is there. Fantastic. I think now we can unmute Mr. T.S. Sivaprasad. Okay, yes, sir. Please go ahead.
Thank you, Mr. Makija, for initiating this IPNet organization.
Thank you.
I'm very happy to attend your programs always. And today also, I'm very much delighted to be a part of IPNet and to hear you and Mr. M.M. Kumar and other personalities, enlightened personalities. I got a couple of suggestions.
Yes, sir.
To reduce the threshold limit to 50 lakhs or even less, particularly for the VOCs, operational creditors, because for them, say, they're generally suppliers in most cases, and sometimes they may not be, say, high value suppliers. There may be small value suppliers only. So it is difficult for them to interact with or join with other, find out other VOCs to make the threshold, to meet they made the demand of 1 lakh rupees, 1 crore rupees as the threshold limit. So I suggest that the threshold limit be reduced to 25 lakhs or 50 lakhs for VOCs at least. Even for otherwise also it should be reduced. Then
on the one hand, one of our friends is saying increase it to 10 crores. You are saying reduce it to 50 lakhs for OCs.
Yes, even that is the opinion of other members also, not only mine.
I believe if I put to poll, you will get almost around, not more, you will naturally get more than 66%, but I believe you'll get unanimous vote from IPs.
Yes, that is right.
Okay, sir, you have any other points, sir?
Yes, my next suggestion is that applicant should deposit at least some 5 lakhs towards expenses or RPs, IRPs fees, etc. Because in many cases, particularly in Bangalore bench, they are ordering for deposit of 5 lakhs, 2 lakhs. So sometimes it is not sufficient to meet the expenses. I know in one case where I'm working as an IR, the IRP was paid 1 is 2 lakhs, and then later, afterwards, he was elevated as the RP. He did not get any amount to. He has to incur a lot of expenses.
I'm just interjecting you here. Don't you think, sir, this kind of deposit of 5 lakhs, is it not dichotomous to what you have said just now? I mean, previous suggestion was operational creditors things should be because they are small people. So if small people are also directed to pay 5 lakhs, how do you think this will shape up?
Now, in that case, say it can be capped to some 10% of the limit or 5%, whatever it is, whatever the NCLT, IBBI, or other dignitaries feel fit.
So
That
a
means
slab can be made, supposing a 600 crore is there, so at least deposit 0.5% of that, right?
sometimes some practical view.
Okay,
Of course, as you rightly pointed out, asking a VOC who has got only 25 lakhs as his plate, say cannot be asked to deposit some 5 lakhs. So in such cases, it can be reduced. At least later, the COC may be asked to deposit the differential amount.
So do you have any other points, sir?
Yes. In CRP order says so the Honorable NCLT should order the CD, then the concerned banks maintaining the accounts of the CD, and local authorities to cooperate with IRP. Otherwise, what has happened is say we had to file for 19 applications, then there will be lot of delay. Then police authorities say that say when we approach for their help, and they say that say they don't have any order.
If it comes as a part of the order, it will save a lot of time, money, and
Yes,
effort.
that is what.
Already probably discussed that, sir. I think, yes.
Yes. Then my last, and this is a query, not a suggestion. Say there is recently there was one discussion paper, and you too had conducted some webinars in association with the Kerala or Kochi Association of IPs, etc. Regarding the reforms in the CIP forms. I would like to know the status of it. What is the update? Whether say when is it likely to be released?
Okay, they are working on it. The backend is ready. They are testing it right now. So probably we'll see it very soon, sir. That is what I can say. Of course, I cannot say on behalf of IBBI. We'll have to have one IBBI representative here. So then in fact, the next webinar, which I think one of our friend will also disclose just now, we are having it on regulatory compliances only. So please attend that, issues which are how to be addressed. And one of the important dignitaries again is coming. So we'll just disclose that in a little while. Okay, sir. Thank you so much for
one more just one point, say one experience. Say recently I was appointed as an IRP, and I approached one of the banks of the CD. And so to give one letter asking them, requesting them to freeze the accounts and to change the order signature to myself. Then they did not even acknowledge the letter. I wonder so why they could not even acknowledge the letter. Say, whereas the other two bankers with whom the CD was maintaining the accounts had acknowledged and taken the appropriate action, but the other bank, the last bank, which is a renowned bank in India, refused to acknowledge it. They said that they have to take the concurrence or directions from their legal department.
Right.
Such is the level of education or information to the concerned banks. So that's why, as I suggested, that as an IBA should direct all the member banks to educate their managers, officers, etc. What should be done, and when the IRP or RP or liquidator approach them.
But are you an ex-banker?
Yes.
Help us connect with IBA. We will, as from IPNet through you, sir, we will also hold programs free of cost. Free of cost. So please connect with them. We are ready to take up, and anyone who wants to come as a faculty, they are most welcome, sir. Okay. So please do that, sir. We'll be in touch offline, sir. So thank you, sir, for your
Definitely. Thank you, Mr. Makijaji.
Please,
I'm
sir.
a great fan of you.
Thank you, sir. Thank you.
I
Thanks for
admire you.
yeah. Thank you for joining. Now I think I'll unmute Mr. Venugopal. Yeah, Mr. Venugopal, you are unmuted, sir. Can you just quickly come and, if possible, friends, open your videos. We want to see your smiling face.
Sir, good evening, sir. I'm calling from Hyderabad.
Yes, sir.
So this is regarding once the RP files a liquidation application with the NCLT, the role ends there itself. So my question, what about the cases pending on the date of filing the application? Because the liquidation order, it took almost 9 months. There are High Court cases pending, and NCLT, there are 2 cases pending. So RP is denied because of the recent amendment. RP is denied of any fees. So he has to work totally free of cost for 9 months, attending the serious cases.
Okay.
So my suggestion, sir, in order, NCLT liquidation order, when there are cases, if there are no cases, the company is not a going concern, it is correct. But when there are cases and the company is a going concern, the RP fees during this period should be fixed by the Honorable NCLT, sir. This is my suggestion.
Okay, great. So you are talking about fees of the RP during the interim period, right? That is there. Mr. Panikar, do you have any comments on this? How should we deal with this?
That's a very an area where we can actually cannot comment. See, basically, so what happens here is it's a function of a bit of legislature also. There's a difficulty which we can comment. We can actually collate this particular thing and we'll work on that. So I think that's better.
Yeah, I think we have noted down. We'll discuss amongst ourselves. Mr. Ravichandran, do you have anything to say on this particular aspect? Fees of the RP once the liquidation application is pending. You are you're unmuted, sir. Please speak up.
There are actually,
sir, the same case, unless they fix some this the particular fees as for the CRP, actually it would be
the same.
It is even difficult to get it because most of the CRP.
Right.
I'll put in a different way. See, what happens here is there are NCLTs where when the RP approaches, they have given. It's actually it's not consistent across all the benches. And in my case, what I've done is when I moved out, that's why I said there should be a legislature intervention here. In my case, I have specifically in the application for liquidation clearly mentioned that this is the money to be, as a CIP cost, and this is passed in the COC, which recommended for this thing. And the moment it is, put to liquidation, it was taken up. But the claiming itself is an issue. So that's an area where we don't have companies, when the CD do not have assets, it's a challenge. And of course, then SEC has to play a role. Since it is judgments will come up.
Right. We will definitely discuss in the lot of study groups are there, friends. Let me also tell you 11 study groups, including CIRP, voluntary liquidation, personal insolvency have been created. Once you go on the dashboard, once you have become a member of IPNet, please select the 2 groups which you want to be there. And these groups will be active only if you are active. Please participate actively. I think that will give us a lot of strength as one force for the IPs. Yes, Mr. P.T. Joy, I think I've already unmuted you. Can you come out, sir, and tell us what is your problem and what is your recommended solution? Go ahead, sir.
Sir, I hope I am audible.
Yes, sir, you are audible, loud and clear, sir. Go ahead.
Sir, in fact, now when it comes to the RP's fees, most of the time, the COC decision, it is written as payable on monthly basis.
Okay.
Why can't it be on payment basis, rather than payable on monthly basis? Sometimes the CRP process, it continues, but the fees, it is defaulted. And when the fees, it is defaulted, it becomes the exclusive responsibility. It becomes the responsibility of the RP to collect the fees. COC doesn't have any responsibility in paying the fee. See, why can't it be instead of payable, why can't it be on payment basis? So that maybe the next month the COC, no, he can raise it in the decision, it is on payment basis. If the fees is defaulted, no, defaulted for the first month itself, or second month itself.
Okay, got your point, sir. Got your point. So any solution for that, sir? Do you want to suggest?
Solution it is, no, see, maybe if that is on payment basis, if the decision it is on payment basis, the RP can come and say that, no, see, your decision itself, no, you have violated, no, you have went back on your decision. Maybe the next COC.
All right, sir. Got it, sir. Thank you for the good suggestion. Mr. Praveen Navandar, I have requested you to unmute.
Sir, I have a short second point now with respect to the fees during the functus officio period. I have the experience now. I filed a case for recovery of the fees during the period when the CRP it concluded, but there was a short gap. No, see on when the liquidation it started, there was a time gap.
Okay.
It was allowed by the RP, and I think no, there is already a judgment. No, the RP doesn't need to file a claim for that because it is part of the CRP cost. It's not a claim.
Right. Got it, sir. Got it. Great, sir.
It is allowed, no, and I have a judgment. In my case, no, I have a judgment.
So please share it with us, sir. We'll also share with all IPNet members.
Yes. We'll share. Thank you.
What we are trying to do. Yes, Mr. Praveen Navandar, can you?
Sir, thank you for allowing me. Sir, in 12A cases, sometimes the 12A cases goes up to 15 to 18 months, withdrawal cases. And whatever the...
और आपकी फीस की गारंटी नहीं है.
No, fees is because we have collected the fees of 1 or 2 months only. Then while withdrawing the corporate debtor, lawyer said that fees will be paid. But then after that 2 years the fees are not paid and nobody is listening to me. And there should be a provision. My solution is there should be that unless the fees are paid, the 12A application should not be withdrawn. In the one hearing, if it is decided, the withdrawal is granted, but subject to payment, and then again the hearing should be there, and the final order should be only after the payment of RP fees. Now what happens? IBBI doesn't look into the matter. NCLT, once the order is done, they don't look into matter. In my case,
absolutely good point, sir. We have got your point.
Case, again the same CD was admitted, again he has filed 12A, again he has come out, but then my fees which is still pending only. For 2 years I am helpless, totally helpless. There is no one to help me. If I do something wrong, IBB will catch me. But if my fees are not received for 2 years, I am out of pocket, nothing.
Sir, let me tell you, at IPNet, we are going to help all IPs. Even if you have some disciplinary matters, please come to us. We are, as a united force, we will try to help you. And in any case, for these other issues also, please raise your point with the IPNet. We will consolidate it and we will definitely put it in a unified voice. Now, Mr. Panikkar, I think you wanted to speak something.
In fact, there's actually a very good, I am not using the word shortcut. See, the moment a financial creditor or an operational creditor, let's talk about financial creditor at this point of time, because he is a part of committee of creditors. He has to give an affidavit that in the event COC do not pay the fees within the CIRP period, he should pay the CIRP cost, at least the fees of the IRP or RP.
I agree, sir. There is no quarrel on that. Fantastic. I think Mr. Pawan Navandar has given a very good suggestion that this order of withdrawal should be subject to the payment of fees.
In fact,
and unless that fees is paid, it should not be allowed to be withdrawn. I think this is something which is fantastic, what he has said.
Bank guarantees or the provision of withdrawal is very clear, but the gap is the issue. What I'm talking about not withdrawal, I'm talking about the CRP case where the RP do not get. There's a mismatch in the cash flow. So that can be addressed by giving an affidavit by the applicant under Section 7 or 9, whatever it is. You have to invariably ensure that IRP or RP's fees has to be paid. Then only it will be allowed.
So you are saying undertaking. Very good point, sir. Very good point. So that will be a legal undertaking and a contempt can also be filed tomorrow. Right.
Absolutely. They should not come with, otherwise they should not come with a Section 7 application before the court. As simple as that. He's an officer of court. He's an officer, not a faltu person. He's an officer of court.
Correct. I think we would like to now hear from Mr. Hari Prasad, sir. You are unmuted. In fact, friends, let me tell you, at transition, we had a lot of study groups which created for this personal insolvency provisions. And Mr. Hari Prasad also was one of the part of it, and he contributed magnificently. I must appreciate his effort. Sir, please go ahead now. And we would also like your active participation in IPNet now. Okay.
Thank you, sir. Thank you for your kind words. Sir, this thing is regarding the panels.
Okay.
There is one IBBA panel.
Okay.
Again, there are panels from each individual banks.
Okay.
Once NCLT appoints me as an IRP, it's well and good up to the IRP tenure. During the appointment of the RP, banks will ask me whether I am in their panel or not. If I am not in their panel, they are not continuing. Previously, they used to mention the same reason. But after NCLT has given some negative for that, they stopped giving the reason, or on some other reason they want to join it. This is like treating some of the IPs as more equal than the others. So, the solution is, I feel that the banks may be asked to select the IPs from the IBBA panel itself.
Okay. But don't you think, sir, it will mar into litigation? Because at the end of the day, NCLAT has actually given a favorable judgment for the banks that they can have a separate panel depending upon the competence, depending upon the case, size of the case, magnitude of the case. I mean, they have separate panels like category A, category B, category C. So I don't know whether that can be disbanded. Your suggestion is nice, fantastic, but I don't know whether it can be implemented that easily. And how you overcome, because you are also a lawyer, how you overcome the legal complications there. So that is what I think. It's a good point. Please join us, sir, our study groups. You be a part of it, and I think we will debate in those angles, right? So a lot of are there, sir. Please come over. I think we need a lot of good suggestions and good discussions which we had during personal insolvency. Great, sir. Thank you so much for joining today. Great. Now I can see Parag Singhal and Vijay Kumar Bhupati. So first, I'll request Vijay Kumar ji and then Parag. Sir, you are unmuted, Mr. Vijay Kumar.
Thank you very much for giving me opportunity, sir.
Great, sir. Please go ahead.
Thank you very much, sir. I'm now 71. I am not handling any cases. I handle 2 cases.
Okay.
One is by the OCs, operational debtors. No contributions.
Sir, number
I'm
one.
coming to solution. I'm coming to solution, sir.
No, sir. You don't look 71. That is what I wanted to say.
Thank you. Thank you.
Right. Okay. Go ahead, sir.
So I am handled. It is transferred by COC, transferred by operational data only. No contribution. There are applications against the COC members, again for non-operation by the CD and COC. All these things have taken place, and even contempt, even court contempt also was initiated by them, by me, and later liquidator also. Then finally, NCLT has ordered to the applicant to pay 5 lakhs as fees to me. Okay. With a lot of settlements, they said we are also suffering losses. We don't get anything. Finally, we have to settle down for 2 lakhs.
Okay.
So after spending so much of time,
right,
we settle down for 2 lakhs. And I also feel that they're all from small and medium scale industry. Understand their problems also. They have come with the expectation of recovering money. Now, and they expect that they should be able to recover the money. What is the objective? When is the IPC initiated is only in the case of default. So for default, they are approaching IPC. Now, an individual or a entity comes like insolvency professional and says, you pay something for our fees. From operational data point of view, it's a very trauma. We already suffered losses.
I agree, sir.
Why would you do that? See, this is from operational data point of view. From financial data, then I handle another case where bank is also involved. Even when they know very well that they are obligated to contribute to CRB, then they don't contribute. And when I file a case in, and the other banker says, you file case against them. When I file them, they don't even represent before the NCLT. And when NCLT finally gives order, they remove.
No, I think we have got your point, sir. I think a lot of.
So what I'm trying to look at is, sir.
Yes, sir.
basically the conflict areas we should reduce in a IBC process. So we should go beyond the law what is present there, denote some reforms. In fact, I sent a mail also, certain points. I've been contemplating on this CRP fund. CRP fund is one of the good solutions which I think it will address the problems of IPs, even the COC members and operational debtors also. See, as a COC member, I'll not be interested in contributing, but as a claimant,
Sir,
when
I think, sir, that point is well taken. In fact, sir, we have created a policy reforms and advocacy study group also. These all suggestions you said we should have a bigger reform. So I think we'll definitely look into that, whatever points you have raised. Now, friends,
there are some more reforms which I wanted to talk to you also.
In the study group itself, we'll discuss about all those aspects.
No, the other person who was mentioning about appointment of IPs later replaced by the IRP. So there also, the power we are judicial officers of the court, Then we should, and all of us will have minimum 10 years plus experience in our mother professions. So we are treated in a way very what do you call it, insulting manner in a way. So it's sometimes we find what there is no worth in doing all these things. We'll have our own honor, prestige in our mother professions. So why do we continue with this?
We got your point, sir. We got your point. Then this is basically the
categorization of CA, categorization of IPs can be done.
Right. Sir, this
in the NCLT panel itself. I would like to go further, say, like what we have is associate charter point, FCA, like that. We can have associate IP, fellow RPs, like that. They can be given complex CDs.
Sir, we have already got your point. We will definitely look into it.
Thank you.
Justice Kumar also mentioned about that, educating and training the members also, so they look at in a respectful manner.
No, training them is one part, sir, but
no, I understand.
Reducing litigation points.
Absolutely, sir.
Reducing litigation points. Why do you create litigation points? Conflicts of interest, conflict areas we should reduce.
Please allow me to go to other members because they have all.
Sure. Thank you very much for the opportunity.
Thank you, sir. Thank you. I think there's one very good suggestion by Ishendra Pandey. I think it skipped me. It is in the chat box. He says, uniformity in allotment of assignments should also be done. I think those are fantastic words which he has written. No doubt about it. Uniformity of allotment so that everyone gets some. Like somebody just now said that some people are more important than the others. Look, like I think Mr. Hari Prasad also raised that point. I think this is one of the fantastic suggestions. Mr. Vikram Kumar, if you are hearing me, do you have any comments on this before I go to Parag Singhal? Vikram, if you are there, if you can hear me. Okay, maybe he's not there. Okay, yes, Parag, you go ahead now.
Sir, as you just mentioned that uniformity of assignment should be there. With the IPs being treated as IPs, how can there be uniformity, sir?
IPs treated as?
IPs being treated as IPs, it is very difficult to have uniformity in the IBC ecosystem so far as allotment of work is concerned.
Actually, you're talking about IPEs. Okay.
Yes. Uniformity is
tell me, you are for or against the allotment of work to IPEs?
No, sir, I am not against. What I'm trying to stress upon is this is a distant dream with IP entities being treated as IPs. Uniformity of work is not. I mean, it's not. It cannot. We cannot. I cannot imagine that.
Parag, let us consider a situation. Assuming I'm just very you see top of my mind. This is coming. Can we say more than 500 crore matters can only be allotted to IPEs? I mean, maybe one benchmark. I don't know whether it is 500 crores, whether 100 crores, whether 1,000 crore. I don't know. I'm just suggesting. Can we have a benchmark that only matters above this limit should be allotted to IPEs?
Yes.
Will that solve the problem?
It may.
I have a very valid some points here. See what happens here. IPE can be formed by persons who are qualified by insolvency examination. There is nothing great about becoming an IP just because that 1 crore paid up capital and other things. But what has happened, the way it has evolved, look at the way IBBA is looking for assigning the people. It's not just people who do not have work getting assignment. No. They are looking at people who have handled it also. There is an no bounden duty on our part, IP's part also, to be extremely cautious because you are an officer of court. Now,
Right.
all this, if you go through the disciplinary mechanism and the show cause notice and other things, it's very, very difficult. How can
Correct.
uniformity cannot happen, according to me.
Okay,
All
I think we'll discuss these issues, sir, in the study groups. I think let's collect some more because we are
One
left.
more point, sir. One more point.
Yeah, Parag, be quick. I'm so sorry, but I think we have to wind up by 6, so we need.
Sir, just give me a minute only.
Yes, sir. Please go ahead.
We agreed with what Mr. Shankar Panikar said regarding the recovery of fees, that affidavit should be filed at any stage, either at the commencement of the CIRP or at a later stage. But sir, at the end of the day, what I feel is, unless honorable tribunals jump in and pass some exemplary orders in favor of IPs towards recovery of fees, it will not be done. It is impossible almost in this ecosystem.
Got your point. Got your point.
Form number 1. What I'm trying to say is a separate affidavit. Like a verifying affidavit, they have to say. That's what I'm saying.
Okay, I think, sir, we can discuss amongst ourselves. We are IPNet, but let's hear other people now.
Thank you very much.
Time is pretty less. So I think now I'm unmuting Mr. Muthuraspuram. So I'm so sorry, sir, if I have not pronounced your name correctly. So please unmute yourself. Yes, sir.
I could be audible, right? Okay.
Yes,
sir, this is again related to the uniformity of assignment, allotment, and other things. One area, especially in the case of real estate, and that is where home buyers are about to select one of the authorized representative, right? And home buyers does not have that much of knowledge when they are getting into the filing of the claim and selecting the thing. And this can be at least done by the IBBI, from the IBBI panel. And that will be at least some bit of work can come to RBI, because the fees has been already fixed by IBBI now for the meetings, and everything is fixed now. So hence this could be one of the area which can be moved into IBBI panel from IBBI.
Great, sir. Thank you so much being a part of it. I think now we'll have to, friends, I think there are a lot of things which are coming up, a lot of issues which are there, but I think we need some more time. We will definitely have more seminars on this, webinars. First, whatever today has been discussed, what has been brought on the table, let us debate it internally. Be a part of the study group. We will send a very valued document, very well thought of document to the IBBI and the relevant authorities. That's my promise. Okay. So now, Mr. Panikar, you'll have to take over now from there for the closing moments. So please take it over from here, sir.
Thank you, Dr. Madhya. This is definitely a totally unique initiative. My only request to all our participants and members of IPNet is, this is not going to be a normal webinar or normal initiative, unless otherwise we rise and speak for ourselves. I, for myself, have decided not to take up IP assignments until things get crystallized. Taking up IP assignment comes with a cost. It will take away your peace of mind. Money comes second. So therefore, unless otherwise we join together and enrich ourselves, stay updated, this is going to be a big time problem. And look at the way judgments are coming. So unless otherwise we have a professional forums like this, where somebody helps us together, we cannot survive this. Otherwise, there'll be a lot of flaws. With the advent of technology, the people getting into judgments across the benches and Honorable Supreme Court, it is going to be really difficult. And in my case, I've seen certain cases where RP had made a process failure. Somehow we managed, pull it up, tight up, and we somehow the RP survives. Now, as simple as getting extension when there is a stay before Honorable High Court of Europe. I'm not going into deeper things.
Okay, sir, I think we can conclude now. So that now what I think we have to invite the announcement for the next webinar, right? So Mr.
Rajib has something to offer us, promise to us for the next. Rajivji, please, you there? No? Yes, Rajivji. Somebody has.
Can we share it on the screen also?
Yeah, good evening, everyone. I am Rajiv Kumar Agarwal on behalf of IPNet. and I am pleased to announce our upcoming webinar titled Regulatory Compliances, Addressing Challenges and Solutions. This insightful session will be held on 14th September 2024 from 4:30 p.m. to 6 p.m. We are honored to have Dr. M.S. Sahu, former chairperson of the Insolvency and Bankruptcy Board of India, as our chief guest, and Mr. Uday Patwardhan, IPNet member, as our distinguished speaker. We look forward to your active participation. Thank you.
Thank you, friends. This is a very important webinar. You can see it on your screen. Dr. M.S. Sahu has consented to come and to give us a keynote address and also to discuss with us the regulatory compliances, addressing challenges and solutions. So please don't miss out, friends. This is one of the important things which are affecting all IP. So one of my suggestion, friends, is not only you, but you must also circulate amongst your IP friends that about IPNet and also about the webinars which are being done. Okay, so now we will move on to the last item.
Yeah, that is next week, same time. Next week, same time is the next webinar. That is 14th.
Now the vote of thanks is also there. Yeah.
And for which I would request Madam Anu Bisani to take over and deliver the formal vote of thanks and conclude.
It's from Hyderabad Insolvency Professional Association. Friends, this webinar was also conducted with 3 partners: Transition, Hyderabad Insolvency, and Kerala Insolvency Professionals Forum. So over to you, ma'am.
Anu Bisani.
Good evening, everyone. I'm Anuradha Bisani from Hyderabad Insolvency Professional Association. I'm the General Secretary. And here I take this opportunity to propose the vote of thanks. Thank you to the entire team of IPNet. This was like a musical premiere show of some movie trailer. So it was a wonderful launch. I tell you, when it started, it was with the music. So I was mesmerized with the usage of technology. So ladies and gentlemen, as we to a close on this historic day, I am filled with immense gratitude and pride. Today wasn't just a webinar, okay? It was the beginning of a new era with a wonderful launch of IPNet. So this platform marks a historic moment for all insolvency professionals, not only for a few of them, but all across India. Professionals, as we unite under one fraternity on one comprehensive platform. Firstly, our deepest thanks to our chief guest, Honorable Justice Mr. M.M. Kumar sir, who called it as a momentous occasion. This is how he started the launch of IPNet. So we thank him for not only launching IPNet, but also for delivering a truly mesmerizing address that has inspired us all. Sir, your words have set a wonderful tone for our journey ahead. I extend a heartfelt thank to our president of IPNet, Dr. Ashish Makhija, for providing a wonderful introduction of IPNet and enlightening us with your vision. Your leadership continues to guide and motivate us, sir. Thank you, Ashish Makhija, sir. And a special thank to you, Mr. Shankar Panikar, sir, for expertly anchoring today's proceedings. Our gratitude also goes to our esteemed panelists, Mr. Vikram Kumar, Mr. Ravichandran, and again to you, Mr. Shankar Panikar, for their invaluable contributions to the discussion on the pain points of the insolvency profession. So the topic itself was like pain points. However, it has to come with a solution. So that was an added benefit for all of us. And this session was wonderfully chaired by Dr. Ashish Makhija. It was enlightening, and I hope it will surely help in paving the way for solutions that support the entire community of insolvency professionals. We are also incredibly thankful to our partners, Transition, the Hyderabad Insolvency Professional Association, and the Kerala Insolvency Professional Forum. Your support has been crucial in making this event a success. A special thanks to Team Transition, led by the visionary founder and CEO, Rashmi Makhija. Your relentless dedication, hard work, tech support, and all backend support have not gone unnoticed and have been pivotal in bringing this initiative to fruition. Finally, HIPAA, Hyderabad Insolvency Professional Association, will continuously support IPNet in all its endeavors to strengthen the insolvency professional. As we look forward to the future, let us carry the momentum from today's successful launch to foster growth unity, and innovation within our community. Thank you once again to everyone involved today. We celebrated not just the birth of IPNet, but the strengthening of the entire IP profession itself. Thank you to everyone. Thank you everyone for your participation and wonderful suggestions. Thank you so much.